first case being argued today, and it is City of Lorain versus Fraternal Order of Police, Lodge number 3. I assume both sides are ready to proceed.
Yes, sir.
We are recording everything, which will be posted on our YouTube channel, as well as just being able to, I guess we're not doing live right now, are we? We're just recording it, just recording, okay. In COVID, we went live too, so I'm trying to remember it all. But anyway, so please stay at the podium and stay there so that we can make sure we have your face and everything, and speak up so we can hear you. And then please do not that you're going to be doing it in this case, but please do not mention the names of any victims or children. We just like to use initials or refer to them as a victim or the child. And we try to tell everybody that so we can remember, as well as the attorneys that come in front of us. So we are ready to proceed, and you each will have 15 minutes, and the appellant may reserve up to 5. Just let me know. Thank you.
If I may, I would like to reserve 3 minutes for rebuttal, please.
That sounds good. Thank you.
Thank you, Your Honor.
You may proceed.
Thank you. Good morning, and may it please the court. My name is Robert Barrett Jr. I'm appearing on behalf of the appellant, FOP Lodge 3, located in the city of Lorain. This case comes before the court as a result of an arbitration award. The parties are signatories to a collective bargaining agreement where they have bargained for a grievance and arbitration procedure, which ultimately led to the joint selection of an arbitrator who issued the award in question. The FOP presents 2 assignments of error before the court today. The first being that the trial court erred as a matter of law in vacating the arbitration award by finding that the award violated public policy. The second assignment of error is that the trial court erred as a matter of law when it denied the appellant, FOP3's, application to confirm the arbitration award. For the following reasons, we ask this court to reverse the common pleas court and remand with instructions to confirm the arbitration award. The Ohio Supreme Court has determined that when reviewing a trial court's decision to confirm, modify, vacate, or correct an arbitration award, appellate courts are to accept findings of fact that are not clearly erroneous, but decide questions of law de novo. It is clear in Ohio that public policy favors arbitration awards and prefers they be left undisturbed. Ohio courts defer to arbitration awards and presume their validity. When parties agree to binding arbitration, they agree to accept the result and may not relitigate the facts as found by the arbitrator. In fact, this court has held that reviewing courts are limited in their role of whether an award draws its to a determination of whether an award draws its essence from the contract or whether the award is unlawful, arbitrary, or capricious. In fact, this court has also held that the review is the narrowest in the law. The refusal of courts to review the merits of an arbitration award is the proper approach according to the Ohio Supreme Court for arbitration under collective bargaining agreements as we have here. The policy of settling labor disputes by arbitration would be undermined if the courts had the final say of the merits. It would sort of circumvent what the parties have bargained for. And in this case, they bargained for a grievance and arbitration procedure for binding and final arbitration.
Let me ask you a question in regard to the arbitration agreement itself. We know that 12434 is controlling in regard to serving, as a police officer and what circumstances they can be removed from. It doesn't require removal, I understand that, but it does, talk about the different issues. Did the collective bargaining agreement refer specifically to 12434?
Yes, Your Honor, it does. It incorporates that. However, when an arbitrator is reviewing a penalty in a case like this or discipline in a case like this, there should be a 2-step analysis to just cause as laid out in 12434. The first step is there just cause to enact any discipline whatsoever? In this case, yes, the arbitrator answered in the positive there. He determined there was just cause to enforce some discipline here. However, the second step of this analysis is the question of whether there is the requisite just cause to impose the penalty that, in this case, the city imposed on the officer. But
the reason why I asked you that is because my understanding is from the trial court's decision that the arbitrator didn't even refer to 12434.
Well, the arbitrator did analyze the entire contract, cited the contract throughout, and touched on the points of, in this case, the act in question was some dishonesty while off duty, and did reference that, which is referenced in 12434. But as you stated, it does not mandate, and this district has held before that 12434 does not mandate the penalty of termination. Similarly, the contract also does not prohibit, the contract between the parties that is, does not prohibit an arbitrator from modifying an award if he or she sees fit. Now, what is prohibited by Ohio law is the trial court improperly reviewing the facts of the case, and the trial court did this on page 5 of its order. First, it reviewed the officer's conduct and disagreed with the arbitrator's findings on mitigating factors present in this case. It reviewed prior discipline of the officer and found that it was in relation to this case where the arbitrator found the exact opposite. Thirdly, the reviewing court also looked at the officer's conduct in relation to the officer's ability to carry out his duties going forward. The arbitrator found that there would not be any issue with that. The trial court found differently. And lastly, the trial court reviewed the arbitrator's decision about whether the conduct was akin to the job, and the arbitrator determined it was not. These are all factual determinations which Ohio law clearly states should be left to the arbitrator.
So you're saying even if factual finding is completely erroneous?
No, if it is clearly erroneous, the court has the ability to review that.
And that's what I was going to get to. So if it is clearly erroneous, like for instance, one of the things that everybody talks about in their briefs and the trial court mentioned, obviously in the trial court's judgment entry, was the trial court, the arbitrator relying on hearsay evidence that nobody really presented. That was huge in the trial, in the arbitrator's decision-making process.
I believe, I appreciate that. I know it was, obviously part of the result. I know the rules of evidence are slightly more relaxed at the arbitration setting, but, for the following reasons, I don't believe necessarily that we should rely on that as heavily, because part of the keys here is that under Revised Code 2711-10, Section D, a court may only vacate an award in the case that it violates public policy here. And I'd like to transition to that slightly to talk about there must be a dominant and well-defined public policy. And unfortunately, fortunately, the trial court and the city are not able to identify a case that clearly states that an officer who commits an act of dishonesty while off duty, not acting under the color of law, and not acting akin to his duties as an officer should automatically be terminated. Now, the trial court does cite Jones v. Franklin County, which is an Ohio Supreme Court case. It favors public policy as that officers are held to a higher standard. And we completely agree with that. And in this case, the arbitrator modified the award, or modified the discipline in his award, from a termination to a 7-month unpaid suspension, whereby when the officer was reinstated, he did not receive back pay, he did not accrue benefits he otherwise would have accrued, and he did not continue to accrue seniority during that time, which is a severe penalty. Now, the trial court also relied on Brink v. the City of Wadsworth, which is a case from this district. In that case, the officer deliberately falsified multiple traffic citations, which are official police reports, while on duty. The punishment from the officer here, however, was not the result of an arbitration, but instead the result of the Civil Service Commission taking action and reviewing a public safety director's termination of this officer. Likewise, the court also relied on the City of Ironton v. Risk from the 4th District in 2010. Here, we had another officer who was falsifying police records and traffic tickets because he had a personal interest in the individuals he pulled over. He falsified who was the actual driver. And in that case, again, like Brink, the officer was on duty, acting under the color of law, and performing actions that were akin to his duties as a police officer. These are very distinguishable from the case at bar, in that, in our case, the officer was off duty, not acting under the color of law, and was instead not doing anything related to his current employment for his current employer, but instead he was seeking other employment with a different employer.
But they were both public entities, they were both police departments.
Yes, Your Honor. And I would also highlight, I know we talked about it, but the trial court also disagreed with the arbitrator's assessment that the officer voluntarily disclosed this to his chief. Yes, it would have inevitably come out, but I think that was a mitigating factor that the arbitrator had, considered and rightfully considered and had the ability to consider. Again, the arbitrator delivered an award that was mutual because the parties mutually selected the arbitrator. It was final, at least that's what the parties intended when they bargained for this. If the parties wanted to bargain that any act of dishonesty would result in immediate termination, whether on duty or off duty, they could have, but in this case, they simply did not. And lastly, the award was on the subject matter. It was relevant to the case. The arbitrator carefully looked at the facts, the aggravating factors, the mitigating factors, prior discipline, and the contract that requires a progressive and corrective discipline, and ultimately issued this award on the subject matter, which is required by 2711.
Don't you think the job of a police officer requires a special kind of trust above and beyond some regular labor arbitrations and disputes?
Absolutely, Your Honor.
For example, they talk about Brady material.
Absolutely, Your Honor, and it does, the court does state, and I will agree with, and we support this, that public policy dictates that officers are held to a higher standard when they're as police officers and even off duty. And otherwise, if some random citizen were to commit an act of off-duty honesty not related to their job, we would be very surprised if they received a 7-month unpaid suspension for their job. So that is being held to the higher standard there. Lastly, I would just like to point out that neither the CBA, the Code of Ethics for the Police Department, and the violations listed within the revised code, and I know we've harped on this, but I do want to highlight it, mandate that the officer be terminated. And the CBA does not prohibit an arbitrator from modifying discipline imposed by the city. Similarly, the arbitrator has that discretion to do so, to review the award, to go through that two-step just cause analysis of 1, is there enough just cause to warrant any discipline, and 2, is there the requisite just cause to warrant the discipline that was enacted. And for those reasons, I would ask that this court reverse the trial court. Thank you.
You have 15 minutes, Carol.
Thank you. May it please the court. Good morning. My name is Margaret O'Brien, and I represent the appellee of the city of Lorain. The trial court's decision vacating the arbitration award should be upheld. The award violated public policy, and the arbitrator exceeded his authority under the collective bargaining agreement. This is a de novo standard of review. You are reviewing the law. The facts are not contested here. Officer Shenik admitted to committing a forging a document to obtain employment with another police department. And Ohio has a well-defined, dominant public policy to terminate police officers who commit a criminal act of dishonesty. It is so well-defined.
Counsel, but he hasn't been charged.
No, he has not been charged with a crime. Unfortunately, numerous people commit crimes and are never charged. In this case, the charging would have to have been done by the North Olmsted Police Department, which had jurisdiction over this crime. Their decision not to charge is not the same thing as the city of Lorain's Police Department might have done. I would further note that there's also a 6-year statute of limitations on a felony charge, so that's not to say that he couldn't be charged in the future within that statutory time. So the policy is also expressed in Revised Code Section 737.11. This statutory section requires that police officers obey and enforce all laws. Case law further supports a dominant, well-defined public policy regarding, again, criminal acts of dishonesty, as police officers must act in a manner that brings respect upon their department. In the city of Ironton versus Rist, this is 4th District Court of Appeals case, the court held that there's a dominant, well-defined public policy based upon 737.11, which precludes an officer's reinstatement after being terminated because he falsified a traffic report. And when I go through, there's a number of cases, and I will go through them, but what's common about all of these cases are these are acts of dishonesty. In the
Now,
first,
but counsel, those particular cases, as the appellant indicates, person is pulled over and they call the daughter up, and the daughter comes and takes the rap. I mean, those are actually, I understand you can argue that this was connected to his employment, but those cases were actually involving your duties, right?
Those cases did involve usually a police officer that was on duty. I would argue that, of course, when they were committing violations of the law, they were not acting under the color of their authority. So they may have been on duty, but all of the cases point out that a police officer, whether on duty or off duty, he carries the cloak, he or she carries the cloak of the authority of the state upon their shoulders. That's what the Ohio Supreme Court said in Jones versus Franklin County. We cannot ignore that police officers do have a higher standard of conduct here. And I believe, as Justice Carr said, the trial court's opinion notes that.
Where did that end in this case? That he's off duty, on duty is a fairly specific requirement to end. If he was on Facebook and lied about whether the Cavs won the game last night, is that dishonesty that can be punishable by termination? Where is there a way to draw this slippery slope to stop? At any point, you're dishonest in anything you do.
Okay, thank you, that's a great question. We all tell white lies. We're all dishonest. At times, we may get on Facebook and brag about a number of things we've never done. That's dishonest, but that's not a criminal act of dishonesty. What Officer Shenik did in this particular case was a criminal act of dishonesty. Not only was it criminal, he did it to obtain employment with another police department. So we're talking about a police department, or a police officer who has a commission with the city of Lorain. The only reason he could apply for that job in North Olmsted is because Lorain held his commission. He was doing a lateral transfer. It's only when he got caught forging this document, and North Olmsted knew that he was forging a document and contacted the city of Lorain, was this brought to the attention of the Lorain Police Department.
I understand your argument. I guess what my question is, more than anything, is it sounds like we're still arguing, well, the trial court just didn't agree with the arbitrator. And the trial court can't just vacate because it doesn't agree with the arbitrator.
I would agree. The trial court can't vacate because the arbitrator, or because they don't agree with the arbitrator's decision. However, that's not what the trial court did. The trial court very succinctly laid out in her order why there was a violation of public policy, and she was very clear. Not all acts of dishonesty, as Justice Stevenson pointed out, would amount to termination of a police officer. She indicated in this specific case, in these facts, with a police officer who committed a crime, who admits to committing a crime under oath, should not be prohibited. It's a violation of public policy to bring him back to work after that. The other case that, as I started to say, was the Jones versus Franklin County case, and this is an Ohio Supreme Court case. This is the case that talks about the heightened conduct for police officers, but what's important to note in that case is the Ohio Supreme Court says, even when off-duty, officials must act in a manner that brings credit, not disrespect to the department. There's no way the union can argue that Officer Shenik did not cause disrespect for his department. The other important factor is the Brady Law. Prosecutors must disclose this type of behavior to any defense attorney. That subjects the officer's work, anything he would do in the future, would be subject to cross-examination, would limit his ability to perform his work as a police officer for the city of Lorain. And most importantly, this court, the 9th District Court of Appeals, in Brink versus Wadsworth, indicated that you upheld the termination of a police officer due to falsification of a traffic citation. As this court noted, honesty is vital in the performance of a duty for a police officer. And as stated by the United States Supreme Court in Kelly versus Johnson, in order for a police officer to command the respect of the public, they must act in a manner that brings respect upon their department. And the Ohio Supreme Court in Southwest Ohio Regional Transit Authority notes that if an arbitration award is unlawful and unenforceable, it violates public policy. It is our argument that this award did violate public policy based on the specific facts of this case and the criminal act of dishonesty. The arbitrator also exceeded their authority pursuant to Revised Code Section 271110D. An arbitrator exceeds their power when the award does not draw its essence from the collective bargaining agreement. This occurs when the award conflicts with the express terms of the collective bargaining agreement and the award is without rational support or cannot be derived from the terms of the agreement. As stated by the Ohio Supreme Court in Cedar Fair versus Fellis, the arbitrator is confined, and this is very important in this case, confined to interpretation and application of the contract. He does not sit to dispense his own brand of industrial justice. In this case, the arbitrator did use his own brand of industrial justice by his own definition of just cause instead of the negotiated definition in the collective bargaining agreement. He was out. While the parties did agree to arbitration, the parties never agreed to the arbitrator acting with that outside of the contract. And Article 9.7 says an arbitrator is without power or authority to make any decision contrary or inconsistent with the agreement. Article 11.1 says non-probationary employees should be disciplined for just cause as defined in Revised Code Section 124.34. Article 11 states that the safety director has the sole discretion to discharge an employee for just cause reasons under Revised Code Section 124.34. Again, the arbitrator never mentions this at all in his decision regarding just cause. Those reasons include an unsatisfactory work performance, dishonesty, immoral conduct, failure of good behavior, and malfeasance. The trial court indicated there were 6 reasons listed under Revised Code Section 124.34 that would be subject to termination. That being the creation of a document impersonating a testing authority, his behavior was dishonest, it was immoral, his behavior violated the department's code of ethics and standards of conduct, and by the way, again, those codes require that he maintain those standards while off duty. And it was a failure of good behavior. It was also malfeasance because he used his commission as a Lorain police officer to attempt to obtain this lateral transfer. The arbitrator's award, according to the trial court, was also arbitrary, which is another reason it should be overturned. And she outlines 5 reasons why that is indicated. The arbitrator indicated the forgery was an isolated incident. However, as noted, honesty is a character trait. Nothing in 124.34 or the collective bargaining agreement requires multiple acts for somebody to be discharged. The arbitrator said, well, his prior conduct's not related to this new charge, so it doesn't count. Again, the collective bargaining agreement, and that's what our authority is. The collective bargaining agreement does not make similarity of disciplinary events a factor. The arbitrator said, well, his conduct's not going to impact his ability to do his duties, and he based that on hearsay testimony, which was objected to at the time of the arbitration. And this just completely ignores the position that the city of Lorain and the Lorain Police Department would be in should they come back and be required, as most police officers are, to testify under oath. How do we put a police officer on the stand to testify if he makes an arrest of somebody who's committed a forgery when we know that he's committed a forgery himself? And we know that because he's admitted to that crime. Again, the arbitrator said, well, he voluntarily disclosed this incident. Well, he only voluntarily disclosed after he was caught. And after the North Olmsted Police Department said, well, we're going to have to call your chief there in Lorain. And I think the part of this that is most, and it was argued again today by the union, it was argued during the arbitration, it's argued in all the briefs, that somehow when he's off duty, his behavior doesn't count. It doesn't matter. He's off duty. Doesn't matter if he commits a crime. There's actually some testimony in the transcript from one police officer who said, well, he didn't commit this crime in Lorain. If he committed this crime in Lorain, we'd fire him. So it's okay because he committed his crime in North Olmsted. And if they choose not to prosecute, then that means it's A-okay. It
Well,
doesn't,
they suspended him for 7 months without paying him. They didn't say it was okay, the arbitrator suspended him and said he should be punished for his activities. Didn't say this is completely all right and fine. So there was some punishment here.
you're correct, Your Honor, there was punishment.
I guess I would ask this, what I understand the FOP to be arguing in part is that the trial court didn't seem to give any discretion to the decision of the arbitrator. They just seemed to almost view it de novo and they could do whatever they wish. Is there any sense in your view the trial court did or should have given any weight or discretion to the arbitrator's findings in this case, arbitrator's decision?
I think that the trial court did assess it and give weight to the arbitrator's decision. She does indicate that she's not saying, and that being Judge Burnside, is not saying that the arbitrator's award, what she said is, not every act of dishonesty would lead to termination. She's definitely basing upon the facts of the criminal act of dishonesty in this case, that that is a violation of public policy there. So I think she does look at the trial court's order, she does explain that. She also, but her decision here is, she is to look under 271110, and that section does require that the award be within the confines of the collective bargaining agreement. And she tells you what the collective bargaining agreement says, and the award is clearly not there. 9.7 says, the arbitrator is without power or authority to make any decision contrary or inconsistent with the agreement. The arbitrator never even referred to the just cause standard set forth in the collective bargaining agreement. The arbitrator doesn't address any of the issues set forth in revised code section 12434. He just makes decisions that says, well, and when I meant that it was A-okay for him to be doing this off-duty, I meant that has been the union's argument from the beginning. At the arbitration, in the briefs, at the trial court, everywhere it's been, well, he was off-duty. Therefore, if he's off-duty and he commits a crime, this doesn't impact the Lorain Police Department. It most definitely does impact the Lorain Police Department. It is clearly linked to his position as a Lorain police officer. That information will always have an impact on the future career of Officer
And
Shen.
unfortunately, your time is up. Thank you. You have just a little under, you see 3.55, so a little under 4 minutes.
Thank you, Your Honor. I'd like to address a few things that the appellee brought up. The first, as I think was pointed out, but I would just like to highlight, while Officer Shen has admitted to his misconduct while off duty, there is no criminal charge in this case nor conviction. Moving on to risk,
What
which
about the fact that, like she mentioned, that it's still within the statute of limitations, they could still charge him?
correct, Your Honor, but that just, it hasn't happened yet. I don't know if it will, it may, but just dealing with the facts before us today, and the case as it is before us today, is that there is no charge or conviction.
Okay, let me ask you this. If he admitted to the facts and the circumstances of what he did, what he's charged with, that's almost like a no contest plea if he were charged. So he's admitting that he committed a criminal act, though, so what do we do with that?
Well, I think we can look at a few cases for that, Your Honor. There is one for the 8th District where an officer was charged with, it was alcohol use, and there were some other offenses, and the officer was reinstated because the 8th District found that not all criminal charges should automatically preclude the employment of an officer. Further, I think the court heavily relies on risk in this aspect, because in
Are
risk,
there any cases involving dishonesty crimes and felonies? Because this would be constitute a felony forgery.
yes, Your Honor, there was, and that was the case in risk, where an officer was committed, I believe it was felony falsification was the case in risk from the 4th District. However, risk has just not been interpreted and expanded upon by Ohio courts. It's recognized by I believe the 8th District here, that at least one Ohio court has found this dominant, well-defined public policy, and that referring to risk against the reinstatement of an officer who falsifies a police report. But there is a distinction here between falsifying a police report, again, on duty, acting as an officer, versus off-duty. And again, I would like to point out, the union is not arguing that this officer is without error in this case, or that we're, I believe the term was okay with what happens while off-duty, because that is not the case here. What we are saying is that the parties bargained for an arbitrator to settle this dispute. The arbitrator has the authority and preference of Ohio courts to settle these disputes, so that every time there's a labor dispute, the parties are not running to court to settle it there in a litigious fashion, which is not very economical for anyone involved, and instead settle it in this manner. And Ohio is highly deferential to the award of arbitrators. It was talked about that the arbitrator dispensed his own brand of justice in this case, and sort of just summarily decided what was going to happen here. I would say that that is not the case. While the contract does certainly reference and incorporates 12434, it does not actually define just cause. It doesn't appear in the statute, and there is no clear definition within the contract. And so the arbitrator did have to rely on arbitral law to determine that two-step analysis that I talked about in my initial presentation. And the arbitrator went through that and said, yes, there is just cause to punish him. No, there's not the requisite for termination, but instead imposed a very severe penalty. Also, I believe the appellee stated that the arbitration award cannot stand because of the provision in the contract saying an arbitrator cannot rule in any inconsistency, or cannot rule in a way that is inconsistent with the contract as negotiated by the parties. However, this inconsistency has not been identified. There is nothing in the contract that's stated that prohibits the modification of an award. If the parties wanted to bargain for that, they could have, but in this case, they did not bargain for that. There is no prohibition on that modification. Back to, and I don't mean to jump around too much on us here, I want to make sure I just address the points as they were. The notion that the behavioral law off-duty does not count. It was a severe penalty, and again, this comes from Jones, where...
You need to sum you're out of time.
Oh.
Actually, I'll let you go over just a few seconds.
I apologize.
No, like I did the appellate too, so.
I apologize, I will just ask this court to reverse the trial court, and the trial court is not permitted to review an arbitrator's reasoning.
Thank you.
Thank you, Your Honors.
Thank you both for your arguments, presentations here to the court this morning. We will take the matter under advisement and issue a written opinion, which will be sent to both sides, and we also report our opinions electronically on the Supreme Court website. So I hope you have a good rest of your day.